Dave, you're absolutely right as far as we've got to stop believing. I mean, how many people here have read, 1984? You know, what's 2 plus 2, Winston? It's 5. And how does the book end? You can't just believe 2 plus 2 is 4, Winston. You got to love Big Brother. In other words, you got to believe the lie and love the person lying to you. And that's the way we are here in America. I mean, listen to what we're talking about here that everyone already knows. The system is broken. It's not going in the right direction. There is no course for change. The Republicans, the Democrats are leading us to a state of decline at this angle, the Democrats at this angle. It doesn't matter. The point is the same. Neither one of them is stopping the direction we're going in economically, morally, or freedom-wise. And when I talk about freedom-wise, that means by obeying the law, having a lawful government that recognizes the law as supreme. They're not going there. The Democrats are teaching us that 2 plus 2 is 5. The Republicans are just teaching us 2 plus 2 is 6. And most Americans believe 2 plus 2 is 3. They don't agree with them, but they're not in the right spot. And what we got to do is start believing that 2 plus 2 is 4. But most people are more comfortable doing what they're accustomed to and believing what they've been brought up to do than changing to the right thing. I mean, look at Moses. Look at the Israelites leaving slavery. Constantly looking back. Let's go back. It's more comfortable over there. We're used to that. We like that. You've got the kidnapped victim syndrome, Patty Hearst. You start loving your captor. And here we are, and what do we say that our solution is? We know the system's broke. We know they don't obey the law. We know we're going on a path of destruction. Yet we're sitting here believing in them, saying they're the ones that are going to save us. You know, if we can just get their ear, they're going to help us. I mean, we talked a little bit ago, we had Dr. Dan over here, saying, hey, what was the good legislation they passed? And we can name like 3 things. Did that change the course we're going in? Yeah, they do change a couple things that give us a little bit of hope. But we've got to look at the big picture. What direction are we going in? Okay, so what we want to do is, to correct this, we've got to learn what the truth is. Can you remedy something if you don't know what the problem is? Anybody seen any of my presentations, and let me get this out of the way first, is one of the things that I want to do is I'm looking for venues, places and people who want to hear this complete story so that we can get our country back. So anyone that wants to further their education on this, come to me at the end. Now, I don't want people to come up to me talking about all the reasons why it won't work and what you can't do and how big the problem is. Okay, I've been doing this for 15 years. I've already heard all those. I'm looking for the people who want to get on board. Let's learn how they took our country, what we have a lawful right and duty and obligation to do, and the people that are willing to stand up for it. But a lot of my presentations, I bring up a Senate report, Senate Report 93-549. It came out in November of 1973. And the opening sentence of this U.S. Senate report says, a majority of the people of the United States have lived all their lives under emergency rule. For 40 years, freedoms and governmental procedures guaranteed by the Constitution have, in varying degrees, been abridged by laws brought into force by states of national emergency. And in the United States, actions taken by the government in times of great crisis have, from at least the Civil War, in important ways shaped the present phenomenon of a permanent state of national emergency. Well, what's a national emergency? A suspension of the Constitution. Government operates in one of 2 ways. Times of peace, Constitution's in full force and effect. Time of emergency, we've got to suspend some rights because we have an emergency going on. How many people here knew or were taught in school that we've lived our entire lives under emergency rule and it has become a permanent state, a permanent condition?
1865.
Okay? We're not taught that. Okay? If you're not taught the problem, can you be taught the remedy? Can you even begin to look for the remedy if you don't know what the problem is? So they admit it. I've got some other slides there I'm not going to go into. And remember what I talked about, Federalist Paper number 39. What this nation was set up as and what the Civil War put into place. I like this bumper sticker here that was out. It's Great Acts of American Defiance. Act number 1, it's got the Declaration of Independence. Act number 2 is, and a lot of people look at this flag right here as racist and all that, and I know I'm in a different crowd here, but I look at this flag right here as being the symbol of resistance to federal tyranny. Okay? That's what I see it as. Okay? Because that's what they were standing up for. federal tyranny, a federal government that wanted to subjugate them and have them not be states and body politics of consent of the governed. The federal government wanted to subjugate them and make them subject to them and have them lose their sovereignty. So I'm going to go back and read Federalist 39, what I read earlier, and I want you to really listen to what James Madison was saying would be if you can nationalize citizenship and how we feel today. It says the idea of a national government involves in it not only an authority over the individual citizens, but an indefinite supremacy over all persons and things, so far as they are objects of lawful government. Among a people consolidated into one nation, this supremacy is completely vested in the national legislature, Congress. In this relation, then, the proposed government cannot be deemed a national one, since its jurisdiction extends to certain enumerated objects only. That's the limited government. Okay? What would change the federal government from a limited government to an unlimited one? Changing citizenship to national. If they can nationalize citizenship, because at that point, all the people are subject to them. Okay? Now, I gave a little bit of a talk earlier. How many people know what the object of the Civil War was that passed Congress? Okay? I'm going to read it to you. This is the Act of July 25th, 1861, because this is very important, because a lot of people think Reconstruction was the logical conclusion to the end of the war. Nothing could be further from the truth. Here's the object of the war. It says, resolved that the deplorable Civil War has been forced upon the country by disunionists of the southern states now in revolt against the constitutional government and in arms around the capital. That in this national emergency, Congress, banishing all feeling of passion or mere resentment, will recollect only its duty to the whole country. Okay, those are flowery words. Here's what the nuts and bolts of it. It says that this war is not prosecuted upon our part in any spirit of oppression, nor for any purpose of conquest or subjugation, nor for the purpose of overthrowing or interfering with the rights or established institutions of those states, but to defend and maintain the supremacy of the Constitution and all laws made in pursuance thereof, and to preserve the Union, and listen to these last words, to preserve the Union with all the dignity, equality, and rights of the several states unimpaired. How many people feel that after the war was over, all of the states had their dignity, equality, and rights in full effect? Didn't happen. Okay? But this is what these northern soldiers went to fight for, even though it was a perverted concept to go and wage war on a free people so that you can force a government on top of them, not of their consent, and of course that'll make them free. Again, it's an absurdity to wage war on a free people to force them under a government they're not consenting to. And also, if you look at that object of the war, and here's a key one that you ought to go look it up, it says the object of the war was not for overthrowing or interfering with the established institutions of the states. What was the established institution of the state they're talking about? Slavery. The object of the war was not to overthrow or interfere with the institution of slavery. It's in the official object of the war passed July 25th, 1861. Okay? And why not? Why would they say that? 30% of the slave states fought for the North. Right? You had Kentucky, Missouri, Delaware, Maryland, and then West Virginia kind of being created in mid-war. 5 states, 5 slave states fought for the North the entire war. Washington, D.C. was a slave territory. Okay? They did not abolish slavery until halfway through the war. If the war was about slavery, they would have done it at the very beginning, and that's just always an argument to take you away from it. The other concept. Let's go to the Reconstruction. Reconstruction's done in 1867, 1868. James G. Blaine. Here's his quote. And this is a quote he gave on August 29th, 1866, talking about the 14th Amendment, because everyone tells us the 14th Amendment is supposed to give blacks, the freed blacks, civil rights. And so that's the 14th Amendment, the Civil Rights Amendment. Okay? This is what James G. Blaine said before it was ratified. And in making this extension of citizenship, talking about United States citizenship, we are not confining the breadth and scope of our efforts to the Negro. It is for the white man as well. We intend to make citizenship national. How clear is that? That's from his political speech given August 29, 1866. And this is a sitting congressman saying that. Okay? Now, how many times you hear people talk about the war was about states' rights? Okay? You hear it all the time. Well, what about states' rights? We just read the object of the war. It was to preserve states' rights, right? Preserve it. Do you think New York farm boy, Ohio farm boy is going to wage war? Because you know what? We hate New York state rights. We hate Ohio state rights. We're going to go fight and get rid of our state rights. You think they would have done that? Not a chance. Not a chance. But look at what James G. Blaine says in his autobiography. I've got this book written in 1888. The title of the book is 20 Years of Congress, 1861 to 1881. And here's what he says about Reconstruction. He says, as the vicious theory of state rights had been constantly at enmity with the true spirit of nationality, the organic law of the Republic should be so amended that no standing room for the heresy would be left. The heresy of state rights. He says the first section of the Constitutional Amendment, talking about the 14th, which includes these invaluable provisions, is in fact a new charter of liberty to the citizens of the United States, is the utter destruction of the pestilent heresy of state rights, which constantly menace the prosperity and even the existence of the Republic, and is the formal bestowment of nationality upon the wise federal system, which was the outgrowth of our successful revolution against Great Britain. I've got more of these quotes showing that the purpose of Reconstruction is to annul state rights, get rid of the 10th Amendment. You know, we got all these 10th Amendment people saying, hey, we just got to, 10th Amendment's dead. 10th Amendment applies to states. When you change every state from the body politic being state citizens, remember what's the synonymous term with the state? The people. The people of the state of Ohio were the free people of the freemen of Ohio. The free people of North Carolina were the freemen of North Carolina. The federal government says, we're going to bestow nationality upon you. Your body politics are not the freemen. It's the United States citizens residing in there. That's nationalizing citizenship, putting everyone under Congress. Again, I'll take question and answer at the end. And I've got quote after quote. Again, for time constraints, we're not going to get into it. I do like this one. Talking about these new constitutions bestowed, like on North Carolina. It says, all were ordained in the spirit of liberty, all prohibited the existence of any form of slavery, and all heartily recognize the supreme sovereignty of the national government. Is that what Jefferson and Washington and Madison put into place? The supreme sovereignty of the national government? I'm telling you, everyone, this is our problem. Okay? Everything else that we pretty much talk about are ancillary problems. They're just problems that created from the initial problem. We've got to hack at the root. We've got to hack at the root cause. What caused the overthrow of the Constitution of the United States of America to where it doesn't apply to the states anymore? And it's this act right here. Did the Reconstruction Acts go before court? Did they ever go, did all this just slide underneath the carpet? Well, there's a U.S. Supreme Court case, Georgia v. Stanton, the state of Georgia going up and challenging this. And here's what the Supreme Court said. This is the December term of 1868, I think. It says, a bill to restrain the defendants who represent the executive authority of the government from carrying into execution certain acts of Congress, talking about the Reconstruction Acts, inasmuch as such execution would annul and totally abolish the existing government, the existing state government of Georgia, is not within the jurisdiction of this court. Just because you have an act of Congress that if put into execution is going to annul the existing state government of Georgia, it's not within the jurisdiction of the court to rule it. Georgia v. Stanton. Okay? The next case, and this is the case I'm going to just spend a little bit of time on, then I'm going to kind of end on that, and we're going to take a little bit of question and answer. Everyone needs to understand a Supreme Court case called Ex parte McCardle. McCardle was a Mississippi editor who wrote in his newspaper he was not for this new constitution that the federal government was forcing upon Mississippi, and he wrote about it, wrote an article in his newspaper. He was arrested by the U.S. military for impeding Reconstruction. Okay? Everyone here knows that Abraham Lincoln suspended the writ of habeas corpus, right? Well, that worked really great after the war, because now the Southerners got to throw Yankee sympathizers in jail, and they didn't have a writ of habeas corpus to go to the Supreme Court. So what did Congress do? They passed an act which opened up the writ of habeas corpus to the court so that all the carpetbaggers and people like that could appeal to the Supreme Court. Well, McArdle used that avenue to get to the Supreme Court. Okay, writ of habeas corpus had opened back up. Well, who defends the United States in a case that's challenging a law, a legislative act of Congress? The Attorney General. Well, the Attorney General at the time was a guy by the name of Henry Stanbury. Henry Stanbury was sitting Attorney General. He was supposed to defend it, and I'm going to read this. This is out of the New York Times the day after this case was brought to the Supreme Court. He said Stanbury had, in accordance with his convictions, answered that the Reconstruction Acts were illegal and void, and had advised the President not to approve them. This being his opinion, he could not, of course, take the other side of the question. Therefore, he had declined to argue it here. He had left it to be argued by those who believed in the doctrine. He had given notice to General Grant, in consequence of which other counsel had been employed. Basically, the Attorney General says, I believe it's unconstitutional. I've already written an opinion it's unconstitutional and given it to the President, because Andrew Johnson vetoed all of them. Okay? He says, Grant, if you believe in it, go hire yourself a private attorney. Is that the way our system's supposed to work? Okay, who did he hire? He hired a guy by the name of Lyman Trumbull. Who was Lyman Trumbull? He was a sitting United States Senator from Illinois. I mean, all sorts of great senators come from Illinois from what I hear. Okay? He never defended the constitutionality of it. All he did was say the Supreme Court didn't have jurisdiction to hear the case. That was his argument. Well, who defended McArdle? McArdle was defended by a guy by the name of Jeremiah Black. Jeremiah Black was former under James Buchanan. He was former Chief Justice of the Pennsylvania Supreme Court. And he's going up here saying the Reconstruction Acts are unconstitutional. Okay? Is he well versed in the law? Absolutely. He was also defended by a guy by the name of David Dudley Field, who was a real heavy hitter, top line attorney. In fact, his brother was a sitting justice on the Supreme Court. So he's defended by Black. Black basically just tears him up. Says, no, I mean, this is just an absurdity, and I'm not going to go into all the details of that. If you want to hear all the details of this, have me come give a talk at your location, and I'll be glad to go over this line by line. I'm going to go to one line that he says here. He says, no judge. This is Jeremiah Black's oral argument to the Supreme Court. He says, no judge who had a clear comprehension of his duty would have asked a man to plead to a tissue of absurdities like that. Yet if the trial of McArdle had gone before a military board, he would not have had the slightest chance of escape, but would have been convicted. Military commissions never disappoint the expectations of those who order them. Okay? Because they wanted to convict McArdle in a military commission trial. He wanted a civil trial. Well, so what happened? Both cases, both sides, they argued it and they rested their side. Trumbull was going to lose. Reconstruction Acts were going to be found to be unconstitutional. Clearly, there's no constitutional authority for them. The amount of constitutional violations are, I think there's 7 constitutional violations to pass the Reconstruction Acts. Okay? So what did Lyman Trumbull do? Lyman Trumbull, who was he? A sitting United States Senator. He went back to Congress, rallied the troops, got them to amend the Act of 1866 that they'd opened up to get people to the Supreme Court on habeas corpus. And that act was amended to the point that any case that had already been argued or was going to the Supreme Court was the Supreme Court could not rule on it. Okay? Now, right now, I'm going to read from you from the congressional record what I just talked about. Lyman Trumbull proposing to amend this act of Congress to take away the Supreme Court's jurisdiction to rule on the McArdle case. And then I'm also going to show you that he was caught in it by another senator, the next speaker after him. And Trumbull says this, and this is again on the Senate floor. He says, in my judgment, there is no such great importance to be attached to it, this act. It is a bill of very little importance in my judgment, and I wish to say to the senator from Maryland that the Supreme Court has not decided that any case is pending before it under the Act of February 5th, 1867. No such decision has been made, nor do I believe any such decision ever would be made. The case has already been argued. He's saying there's no case up there. And he argued it. Okay? He goes on. He says, now there is no such a case that is pending in the Supreme Court, and there has been no such case pending in the Supreme Court. Well, there's a Mr. Doolittle out of Wisconsin. He's a senator from Wisconsin, Democrat, and he says, Mr. President, my honorable friend from Illinois seems to think that there is no importance to this measure, that it affects nothing and nobody, that there is no case pending in the Supreme Court which this act will affect, that it is a mistake and a delusion on our part to suppose that there is any such case under the law of 1867. Well, sir, if he be correct in this, why the great haste in pressing this bill? What does it mean? Sir, I apprehend that the honorable senator from Illinois is altogether mistaken in his view, which he now presents, that this is a very important measure, that there is a very important case pending in the Supreme Court under the Act, which it is now proposed to repeal. The honorable senator himself, as counsel in that court, if I am correctly informed, with other counsel, made a motion to dismiss a case pending in the Supreme Court, or alleged to be pending under this Act, and the court refused to dismiss it. And he goes on, he says, we all know, the whole world knows, that this case of McCardle is pending in the Supreme Court, brought up on appeal under the Act of 1867 from the Circuit Court of Mississippi, and that case has been argued by eminent counsel, and that it is pending. It is an important case because this case involves the constitutionality of the Reconstruction Acts. It involves the constitutionality of those acts which have been passed by Congress. If there be no such case before the court, why does the honorable senator desire to pass a bill to take away jurisdiction of a case that does not exist? Okay? So, I'm not going to go any further than that. I've got a lot more information, but I want you to see that this act has not gone under the radar. It's not some figment of somebody's imagination. It's not cobbling together a little fact here on the internet and something obscure over here on the internet and trying to put a thing together.
Would you explain the consequences of McCardle if he would lose? What the sentence was for going against Reconstruction?
Oh, well, it was potentially hanging for McCardle. But they ended up not hanging him and let him loose. And there was another case that came afterwards, which, again, we don't have time to go into. But the bottom line is this. This is out of a book called Landmark Cases of the Supreme Court. And it's got the McCardle case in it. And here's the ending footnote. And this is a modern publication which talks about the McCardle case. In the ending footnotes, it says this on this case. It says, while the case was under advisement, Congress passed an act taking away the jurisdiction of the Supreme Court as defined by the Act of February 1867 in cases of habeas corpus. And the appeal was therefore dismissed for want of jurisdiction. McCardle was thereupon discharged, and no further attempt was made to test the constitutionality of the Reconstruction Acts. It's been sitting there ever since. The nationalizing of citizenship has been sitting there ever since. Well, like I said, our belief is that the government supplanted, the body politic supplanted by the United States Congress and the Reconstruction Acts is still there and viable and has never been changed by the consent of the free people of North Carolina or any other state. And that we have a right to just owe allegiance to it. We have that duty. And then, once we are state citizens, like I said earlier, if they try to say we're subject to them, now we're an injured party, and we can seek redress. Now we have a conflict. That's why, again, I don't have a driver's license. That creates a conflict. John Ainsworth, you don't have a license. Big Brother says you're supposed to have a license. I'm saying, I don't think the Reconstruction Acts were lawful and constitutional. I don't recognize your state as being lawfully created. So we've been taking this to court since 1998. We've been doing this for a long time, and I want to do one thing to kind of clear up a couple things. There's a lot of groups out there saying that they're the Republic of North Carolina, they're the sovereign people re-inhabiting. I know of at least two other groups. One is under a guy by the name of Tim Turner, who was just recently arrested down in Alabama. They had a Restore America plan called, I call it TRAP. I talked with those people. They have no legal foundation whatsoever for what they're doing. And there's another group that's led by a guy here in North Carolina by the name of Mark Wadsmith, and they have no legal foundation. In fact, Mark Wasmuth has started taking my arguments and trying to pitch them to spread all this, but they have no allegiance to an original state. They have no laws. They are a fraud and a usurper. But here's what we've done. We've been getting cases. This right here is a brief to the United States Supreme Court for Isaac Birch. We actually got a case to the Supreme Court. This is January 22nd of 2012. And this is what a Supreme Court brief looks like. It's got to be bound and printed just like this. Here's the questions we're asking the Supreme Court. 1. Did the Congress exceed its limited enumerated powers when, through the Reconstruction Acts, it authorized military force to nullify the constitutional government of North Carolina and to substitute in its place an electorate, which is the body politic, and a government molded to the will of the Congress? And question number 2, when challenged with substantial evidence to the contrary, must the existing government of North Carolina prove the lawfulness of its claimed jurisdiction over the petitioner, one of the people of North Carolina? So we're fighting this in court. We're taking this very seriously. We believe we can get our country back with a legal argument if we will just pick it up. Like I said, we've been sitting here talking about, we know the systems of fraud. Why are they there? Because we have some strange addiction and love to them that we refuse to let our captives go. The power resides in us, not asking permission of them. Not saying if we can get the right one of them into office, they'll help us. They won't, people. They will not. It's proven. We're going in a direction of destruction. The only way to fix this is for the people to exercise their sovereign right to reestablish lawful government. Then we can go back on the money standard. That puts the Constitution back in a position to where there are states again which limit federal authority. It's unlimited if you're a United States citizen. I'm going to say one other thing here, then I'm going to take questions and answers. A United States citizen has no authority to resist or to organize resistance against the United States government, morally or legally. A state citizen does, because a United States citizen, by definition, accepts the laws that they pass as legitimate. If you want them to act like the federal government, a limited federal government, it's only limited to states. It's not limited to United States citizens residing in states.